Thank you for attending Balancing Act, Regulating Intoxicating Hemp Products in Ohio. The event is hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for this event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Patty?
Thank you, Holly, for laying down the rules of the road. And thank you to everyone who is here for joining us today to discuss the regulation of intoxicating hemp in Ohio. My name is Patty Zettler, and I have the pleasure of moderating today's webinar. I'm the John W. Bricker Professor of Law here at Ohio State, and I'm also a faculty member of the Drug Enforcement and Policy Center. And for this semester, our acting academic director, while Professor Doug Berman, who many of you may know, is on sabbatical. I also previously served as Deputy General Counsel to the U.S. Department of Health and Human Services, and so I'm very interested in the topic of intoxicating hemp, as I know all of you are as well. So today we are fortunate to have a fantastic and deeply expert panel here to help us understand the important and complicated issues around intoxicating hemp. I'd like to invite the panelists to go ahead and turn on their videos. I will briefly introduce each of our panelists, and then I will ask them a number of questions to help us understand the landscape here. As Holly mentioned, we will leave some time at the end for your questions as well, so please feel free to put them in the Q&A as Holly instructed as we go along. So our first panelist, I'll just go in alphabetic order, is David Bulling. David is the Executive Director of the Ohio Cannabis Association. He previously served as Deputy Superintendent and Deputy Chief Legal Counsel with the Division of Cannabis Control in the Ohio Department of Commerce. And David has a long record of public service, and outside the cannabis context, he also served as an attorney for the Ohio Secretary of State. David earned his law degree from the University of Dayton and his undergraduate degree from the University of Kentucky. Our second panelist is Jonathan Miller, and Jonathan is a partner with Frost Brown Todd and serves as partner in charge of the firm's DC office. He is a leading government relations professional and attorney for the global hemp industry and serves as general counsel for the U.S. Hemp Roundtable. Like David, he has a long record of public service and a wealth of government expertise, having served as state treasurer and the Secretary of Finance and Administration for the state of Kentucky, and also as deputy chief of staff for the U.S. Department of Energy. Jonathan earned his law and undergraduate degrees from Harvard University. And last, but certainly not least, we are fortunate to have Michelle Minton joining us as well. Michelle is a senior policy analyst at the Reason Foundation. Among other work, Michelle co-authored Reason's report examining how states regulate intoxicating hemp products and providing recommendations for state and federal legislation. Before joining Reason, Michelle was a senior policy analyst at the Competitive Enterprise Institute, and Michelle earned her Master of Science in Nutrition Sciences from the University of New England and her undergraduate degree from Johns Hopkins University. So we have a terrific group with a lot of expertise here. Thank you to our three panelists for joining us. And Michelle, I will start with you with our first question. Michelle, could you please talk a little bit about what intoxicating hemp actually is? How did these products develop? How did the market for these products develop? And just sort of help us understand what we're talking about today.
Yeah, absolutely. And thanks for having me on this panel of distinguished guests. So the first part of the question, what are intoxicating hemp products, could actually have three different answers: the chemistry answer, the practical answer, and then a legal answer. And I won't bore you too much with the chemistry, but basically in a nutshell version, intoxicating hemp involves plants or derivatives of the hemp plant that contain cannabinoids known to produce impairing psychoactive effects, not just psychoactive effects, but impairing, and that have these cannabinoids in high enough concentration to have that effect. But as I think state lawmakers and law enforcement across the country have been dealing with, it isn't actually so easy to classify the more than 100 cannabinoids that have been identified in cannabis plants into these neat categories of intoxicating and non-intoxicating. So as I'm sure most of the guests watching this understand, hemp and marijuana both come from the same plant, the cannabis sativa L. And like I said, there's over 100, some people estimate 150 different types of cannabinoids that naturally occur in these plants. The two most well-known classes of these, or cannabinoids that we know of, are tetrahydrocannabinol, THC. Obviously, this is your delta 9s, your delta 8s, the ones that most people associate marijuana with the psychoactive effect of being high. And then there's cannabidiol, or CBD, which is considered psychotropic. It does have an effect, but it's not considered intoxicating. Then there are a whole bunch of isomers of THC, which a lot of states are dealing with now, like delta 8, that occur naturally in the plants, but typically in lower concentrations than the most common one of delta 9 THC. In addition to this, a lot of those cannabinoids go through a natural form of synthesis where they change from one form to another, just sort of the molecular composition remains the same, but the molecules just kind of get shifted around a little bit. So for example, if CBD is exposed to light or heat, it can be converted into delta 8 THC or delta 9 THC. And then there's, if anybody knows about THCA, it's a cannabinoid that's considered non-intoxicating when it's inside of the plant. But if it's heated up, for example, by smoking or vaping, it gets converted into THC. And then there's also chemical synthesis that can happen. This is how we turn CBD, in a lab by applying solvents into delta 8 THC. And then there's a whole other class of artificial cannabinoids that do not occur naturally in the plant that are completely created in a lab that mimic the molecular structure and effect of THCs. So that's your nutshell version of the chemistry answer. The practical answer is that with all of these different cannabinoids, they have different effects. There's also an entourage effect where different combinations of cannabinoids may make a product or plant material considered intoxicating or non-intoxicating. For example, you can have a pretty high THC concentrated hemp product, but if it has a much higher ratio of CBD, it does not exactly produce the same types of intoxicating effects as it would with lower levels of CBD. Oh, that's practical. Now you have the legal answer. So back in the 1970s, a botanist and a taxonomist said that they were arbitrarily creating a distinction between what hemp and marijuana were, and they based this on the concentration of specifically delta 9 THC in mature leaves. And as a side note, there's far fewer cannabinoids in the leaves of a cannabis plant than there are in the flowers. And the limit that they chose was 0.3% delta 9 THC. And in 2018, the federal government adopted this standard in the 2018 Farm Bill of saying that legal hemp would be considered in all of the hemp plant materials, seeds, derivatives, extracts, isomers, any part of the hemp plant, so long as that material had less delta 9 THC concentration than 0.3%. And once that federal bill was passed, states started to adopt the same standard. And what this did, obviously, as we all kind of recognize now, is it paved the way for all of the other forms of THC and other forms of cannabinoids that are in cannabis plants to be concentrated and sold technically legally under federal and most state law until recently. So now we get into, that's how the plants operate and the cannabinoids. How did the market itself for intoxicating hemp products actually develop? The short answer to this is supply and demand. With the 2018 Farm Bill and starting in 2014, a lot of states had their own pilot hemp programs. By 2019, there was a big glut of CBD produced by hemp farmers, and there wasn't a way to get that necessarily to the market. This partially because of improper regulatory schemes that created a sort of mismatch. The demand wasn't there. There weren't the regulations for these processors to actually produce CBD products to get them on the market, and there was fear about the legality. So you have a glut of CBD just on the market, and it caused the prices to crash. At the same time, the legal marijuana market was accelerating, demand was increasing, and the prices for those products were skyrocketing. So you have the hemp industry, and the reasons that there was a lot of unmet demand in the marijuana industry, in the legal marijuana industry, was frankly because of the way states were forced to regulate legal marijuana under federal prohibition. So, a lot of states, in Ohio, for example, many localities have a moratorium on legal sales. In California, you have about half of the population in California, the biggest legal marijuana market. Half the population lives more than 60 miles away from the nearest legal retailer. So there was an unmet need. And hemp producers with their glut of CBD saw this unmet need and tried to figure out a way to turn their CBD into a product that there was demand for consumers and that they could be profitable with. Magic presto, we've had the chemistry since the 1960s to do these relatively simple conversions from things like CBD to Delta 8 or Delta 9. And with the federal laws being what they were, hemp operators, producers, retailers saw an opportunity to meet the demand of the legal marijuana market without running afoul of federal or state law at that time. Because hemp producers had fewer regulatory barriers, they didn't have limited licensing, fewer licensing costs, they could get these products in more stores, closer to the consumers, better hours. They were just more competitive in a lot of ways than state legal marijuana products were. So, to put it in another way, if the states had been able to regulate legal marijuana in a way that met the demand that existed, intoxicating hemp products probably would have never emerged as a real market. So that's the short answer of how this market emerged and what these products are.
Thank you. That's really helpful. David, Jonathan, do you have anything you want to add from your perspectives?
I'm happy to. What's intoxicating? That's really a huge $1 million question because different things intoxicate people differently, and there's been an effort nationally to try to figure out how we can segregate intoxicating versus non-intoxicating products. And so far, no one's come up with a really good answer. Kentucky's got a good model that I can share later, but this becomes a real challenge because you have some policymakers, such as in Ohio, using a very low level of THC to say what's intoxicating, what's not. And we believe that it excludes a lot of non-intoxicating products like full spectrum CBD products that don't get people high, but that are somehow pushed into the intoxicating category. So this debate between intoxicating versus non-intoxicating is a huge one and might not be resolved for some time.
Well, the lawyer in me loves acknowledging that our starting premise of talking about intoxicating hemp isn't clear in and of itself. So David, do you have anything you want to add on this question?
I just like to give like a real world comparison as to kind of what's going on here. So the one that I always like to use is let's take a potato farmer. A potato farmer grows potatoes, sells those potatoes to McDonald's. McDonald's makes French fries out of those potatoes. Those are all potatoes, right? I think we all can agree on that. However, what we have going on in the intoxicating hemp world is we've got a farmer similar to that. Is we've got a farmer who grows potatoes, turns that potato into vodka, and then wants to sell that vodka at retail, but still call it potatoes when it's in the retail store. That's my real world comparison for what's going on here in the intoxicating hemp market.
Thank you for sharing that. And actually, David, I'm gonna stick with you and in fact turn a little bit more specifically to Ohio. And so I'm hoping you can help us understand how intoxicating hemp products, however we might define them, are currently regulated under Ohio law. Things like who can purchase the products, where can they be purchased, what kind of limitations are there under Ohio law on what kinds of products can be sold.
Bottom line, right this second, they're not regulated, period. They're not tested. We don't know who produces them. The consumer has no way of finding out who produces them. You have no traceability in this particular market right this second. The short answer, and I don't have to go too far into it, is they're not regulated.
Jonathan or Michelle, would you want to add anything? Jonathan, I know you touched a little bit on how Ohio defines intoxicating, but is there anything else you want to touch on with respect to Ohio law?
Right now Ohio law is quite limited, and the hemp industry would like to see much more robust regulation. The problem about having limited regulation is that it advantages bad actors. And so there are a lot of really good companies in Ohio and across the country that take great efforts to make sure their products are properly labeled, kept out of the hands of kids, kept contaminants out of. That costs money. And so they're competing with hemp companies that do none of the above. And so this is one of these rare industries where the hemp industry is saying, please regulate us, because not only is it good public policy, but it helps our bottom line by advantaging the good guys against the bad guys.
Yeah, and I would add to that, I mean, I concur with what Jonathan said, and I'd add to that, there is a lack of federal guidance too, that's in a lot of ways, with marijuana, the federal prohibition is really hampered the state's ability to rationally regulate their marijuana markets. When it comes to hemp, the total lack of action from the federal government to provide certain guidance like good manufacturing standards, what kind of ingredients should be excluded, testing standards, and probably most importantly in the conversation about hemp, how some of these cannabinoids like CBD can be safely added into foods and beverages. So states have had to hold back and waiting for the federal government to act. And so you have a situation where, Jonathan mentioned, where you have hemp products that are, in a lot of ways, the industry is self-regulating, and you have good actors who are following specific guidelines similar to adult use marijuana markets, and then others that aren't doing that. And you have a real kind of lack of transparency, as David noted.
Yeah, and I will add with my own FDA hat on that it does violate federal law to distribute food and beverages with CBD in it, but FDA has not been enforcing unless products are marketed with claims of disease treatment, and FDA has publicly said that it thinks it thinks Congress needs to act to create a more rational scheme for the sort of food regulation piece at the federal level.
If I could jump in real quick.
Yeah.
We disagree that CBD products violate federal law. That's certainly the FDA's position, but it's just a non-binding statement that they've made, and we feel that if it was ever tested, we would win in court. But you are very correct that they haven't tested that, except going after those bad actor companies who are breaking the law by making medical claims.
Well, we can have an offline chat about that, but the statute does prohibit adding approved drugs to food absent, regulation or other official sort of exemption, which doesn't currently exist. And of course, as you know, CBD is an approved drug. But I do want to back away from federal law just for a minute and stick with the states. And so David kindly talked with us about sort of what Ohio law is. Jonathan, I know you've done a lot of work on a lot of different state areas. And I think it would be great to understand better how Ohio compares to other states when we're talking about intoxicating hemp. So, is Ohio an anomaly compared to other states? How do other states, including neighboring states, approach regulation of these products? And maybe you could talk a little bit about what the impetus behind regulation is, if there are states that are doing things differently.
Yeah, Ohio is very similar to most states where there's a lot of gray and so what you've seen states try to do, filling in the gray, is to either A, robustly regulate products, or B, ban them. We prefer the robust regulation, obviously, and one of our favorite states is just south of the Ohio River, where I'm from, in Kentucky. Kentucky has a very strong regulatory model, which provides for age restrictions, testing, GMP requirements, labeling requirements, and it's proven to be quite successful. You've seen some other states like California move to ban products entirely. And so the governor of California just issued an executive order late last year, which says that all hemp products with any THC in them are banned, which is basically 90 to 95% of hemp products. You're starting to see those kinds of efforts be proposed. Similar proposals going on in Texas, a similar one in Illinois, but so far efforts have been successful to keep them at bay. But this is a continuing debate going on, and unfortunately for us, we have 50 different state regimes, which can be quite challenging if you think of labeling. For instance, if one state requires you to list how much THC you have in a product, and another state says you can't use the word THC on your product, you see that you can't have that same label. And so we're having folks that sell across the country have real challenges in terms of interstate commerce and complying with different state laws.
Yeah, and that certainly seems like an argument for more federal more federal guidance. Michelle, David, do you have other thoughts to add about other state regimes outside of Ohio?
No, I mean, I would just add that I think it's interesting that more and more states seem to be taking a harder line. I think Ohio, right, the second is in the minority on limitations and, you know, perhaps all out prohibition. You know, it's interesting to me that more and more states seem to be going in the direction of banning intoxicating hemp.
Yeah, and I would add to that, it's very interesting to look at which states are taking the harder line versus the more, regulatory based approach, like with Kentucky and Tennessee. It's often the states that take the more regulation heavy approach are the ones where cannabis is not yet fully legalized. Marijuana is not yet fully legalized. And the title of this panel is balancing. The balancing's in the title, and I think that in a lot of ways what lawmakers should be doing, and not just balancing consumer safety concerns with industry concerns, but balancing the ability for a good-willed industry to comply with the laws versus the will of the people to obtain these products as whatever product it is they desire. Because if they can't get it on the legal market, they will turn to out-of-state products or illicit products or a different type of product that's being sold as a similar product. It's what we saw with hemp cannabinoids to marijuana. We've seen it in the opioid market with fentanyl and now xylazine. We've seen it in the alcohol market during original prohibition, where people were dying of, contaminated or poorly made alcohol products. So I think it is interesting to see the different tax people are taking. And I think a lot of the states that approach it through prohibition is frankly from this fantasy that if you just ban a product, that will take care of the problem. And it's certainly easier for law enforcement, but from experience, it doesn't typically work out well.
Before we move on to our next question, which someone in the chat has already asked about, I guess I will have a follow-up question for you, Michelle, which is you mentioned that the states that are moving towards prohibition have already robust state legal cannabis markets. So I guess do you have a sense of why that existing market is pushing those states to prohibition rather than regulation?
Yeah, there's a number of reasons. For one thing, it's more difficult to regulate a larger number of products that can be produced from hemp. It's fairly easy with cannabis, just like Delta 9, it gets to above a certain concentration, it's intoxicating. The other issue is that you have kind of fragile markets. I mentioned before that the marijuana market demand was increasing, prices were increasing, and that's changed since 2022. And a lot of the markets where you have big state legal marijuana markets are suffering. They're suffering. A lot of, I think in California, it's still, 50% of all the sales that occur in marijuana are through the illicit market, which is huge. And a lot of this is being driven by the fact that people can't access the products they want legally, where they want, when they want, and at prices they can afford. And sometimes it's just the products aren't available that they want. So I think that's we're seeing a little bit of a protective stance to protect the cannabis markets that exist, the tax revenue they're generating, and sometimes the social equity programs and other programs that they're funding from this new competitor that's facing a lot fewer regulatory hurdles and costs.
Thank you for fleshing that out a little bit. So someone in the chat asked if we could talk a little bit about Senate Bill 86, which I love because I was already planning to ask David about that. So David, if we could turn back to Ohio and talk about the recently introduced Senate Bill 86, which proposes to regulate intoxicating hemp products. Could you walk us through a little bit of what the main provisions of this bill are, what it would change about law in Ohio?
So Senate Bill 86 provides for a regulatory framework for really two types of products: intoxicating hemp products and another product that they refer to as drinkable cannabinoid products. It separates them into kind of two distinct regulatory fashions. On the intoxicating hemp side, it forces them to be sold through licensed regulated dispensaries in Ohio, which we have established that framework in Ohio. They're licensed by the Division of Cannabis Control. And then it says further that it does place limitations on what is intoxicating hemp from a THC content perspective. So part of what it does is carve out those products that are non-intoxicating to make sure that the hemp market can still flourish in that front. So it lets those lotions and things exist that we're all familiar with, but also forces the intoxicating products through retail dispensaries that are, regulated, heavily regulated, and tested. Again, it does require similar testing to current marijuana products in the state of Ohio. And then the second kind of regulatory framework is the drinkable cannabinoid products, which it sets up kind of a three-tier system. I hate saying that, but that's kind of what it is for manufacturers, retailers, and distributors to create these drinkable THC products. It sets limitations on them as well. I think the actual number is it's 0.4 milligrams per fluid ounce of THC. So in a 12-ounce can, 4.8 milligrams of THC is really what you're going to get. And it sets up a framework where it's capped at 48 ounces. So really what you're talking about is 4 milligrams or 4 to 5 milligrams of THC per can with a limitation of 4 cans per package. And then it allows for those particular products to be sold at micro distilleries, grocery stores, bars and restaurants, and also retail dispensaries as well. It forces those folks in the three-tier system to be registered with the Department of Commerce. Again, so they're regulated by somebody, by an entity. And I'll just throw in the tax provisions. It's taxed at a rate of 15%. Now, we heard the other day that the way the bill was introduced, it's at 15%, but likely to come down to 10. Senator Huffman said that in his testimony. And there's an additional tax at $3.50 per gallon on the sale from the manufacturer to the distributor. All of those funds fund the general revenue fund in the state of Ohio. That is Senate Bill 86 in a nutshell.
Thank you for summarizing it so concisely. So Jonathan and Michelle, if you have things to add about how to summarize or sort of what the bill would change, I'll let you sort of add that to your comments in the next question. But I actually want to ask all three of you from your perspective and from the perspectives of your stakeholder groups, what are the strengths and weaknesses of Senate Bill 86 and what are changes, if any, you would like to see? And David, since you were just talking about Senate Bill 86 yourself, maybe I'll start with you and then go to Jonathan and Michelle.
Yeah, I mean, aside from some various technical fixes that I don't really want to get into the weeds on, I mean, there's things that we believe testing could be beefed up a little bit in the bill, could increase a little bit on where you can source the THC from. So aside from those changes that are, like I said, they're very technical, we think the bill is in a good place. Like I said, it does establish a regulatory framework for these products, and that's bottom line what needs to happen.
Jonathan, do you want to share
Yeah.
next?
Yeah, and we strongly oppose the bill. The hemp industry is pretty united. What it really amounts to is a retail ban of most hemp products. This is better than the bills introduced before because there is a carve out, as David mentioned, for beverages, but products like non-intoxicating CBD that are a little bit above the 0.5 milligram level, even though they're non-intoxicating, would only be available in dispensaries. And frankly, people go to dispensaries to get high. They don't go for health and wellness products like CBD. So it would amount to a real hardship for a lot of consumers who rely on these products for their health and wellness. But most certainly, by giving the monopoly of the sales to the dispensaries, you're cutting out all these small businesses that have grown to sell these products, as well as hurting farmers who are trying to provide the hemp to be in these products. So we're supporting efforts. We know that the current status quo is not acceptable. There needs to be more robust regulation, but we don't think a retail ban is the right answer.
And I guess, are there changes you would want to this bill specifically to address those concerns? Or do you think, I guess, is your perspective, it's just scrap this one, we need something wholly different?
Yeah, we need something totally different. We've put together a kind of a proposal with some other hemp organizations in terms of what a robust regulatory structure would look like, and it really is substantially different than this current bill.
Michelle? Oh, David, do you want to respond, or
Wouldn't mind responding if that's okay.
how about I let Michelle her piece, and then you can respond to both.
Hey, don't forget what you're going to say, David. Yeah, so, there's some things we like in the bill, age gating, testing, robust testing, packaging and stuff that's similar to or equivalent to the adult use marijuana market. We also particularly like that it allows for just any accredited lab to do the testing, not a state-run lab, which can cause bottlenecks. But there, as Jonathan said, this pretty much, it's as close as you can get to prohibition without it actually being prohibition, to move most of the products into the dispensary system where, like I said, in Ohio, 55 municipalities have already established moratoriums on dispensaries. So you're going to be forcing people to drive farther to find a dispensary to get this legal product. Dispensaries, it's unclear once given that particular product class if they will modify their offerings to the group of people who want to use like high CBD, lower THC products. There are some pediatric patients out there who have particular seizure disorders who are taking up to 800, 1200 milligrams of CBD, which if you are talking about a natural full spectrum CBD product, that comes with not an insignificant amount of THC, definitely an amount that would crest over what we would, what this law would consider to be intoxicating. Putting it in the dispensary wouldn't just kind of create hardships. It would also very likely significantly raise the costs for people who are taking those substantial amounts of CBD just through all of the barriers that increase costs for the dispensary model. And like I said, if consumers don't have the products they want at the prices they want and they don't have access to them, they will turn somewhere else. And in this case, the most likely one is to out-of-state products, which is going to cause a lot of headaches for a lot of people. Law enforcement, public health, not necessarily knowing what these products are, where they're coming from, if they're, verifiable, that kind of thing. We would also like to see the inclusion in bills like this of the CBD to THC ratio, not just a simple concentration limit or a simple milligram limit in products, but as I mentioned before, the entourage effect of these cannabinoids. When you have a lot of CBD, even with more THC than you think would crest over intoxicating, it's not intoxicating. So we'd like to see this ratio to kind of give patients a little more leeway when it comes to where they can get their products. I'm glad David said about the tax, because the tax disparity between legal marijuana dispensary sales and then the 10% versus 15 didn't quite make sense. There's also a cash limitation in the bill that does not make any sense to me, where business to business transfers of intoxicating hemp products, specifically the drinkable cannabinoid products, could only be done in cash, which I think we can all understand what the troubles that might cause for businesses. And I think those are, for us, we would like to see states take the opportunity. Their adult use marijuana markets were created under, with one arm tied behind their back because of federal prohibition and a lack of interstate sales. We would like to see states kind of start from square one and create a market for intoxicating hemp products that they would like to see for their marijuana products, a more liberated market that's still well regulated and controlled and transparent, so that if and when the federal government ever removes marijuana from the Controlled Substances Act, they could then use that as a model for both of these products to be a unified regulatory scheme.
All right, David, what do you have thoughts about Jonathan and Michelle's comment?
Let's clear something up on the cash transfer that Michelle was talking about. It's a framework that's stole from spirits, beer wine world. It allows for people to not sell on consignment. It's something that distributors and manufacturers in the beer wine world are fully familiar with, and it's shown to work. But to call it a retail ban is just interesting to me. We have roughly 300 dispensaries across the state. with the division's ability to increase those dispensaries based on demand. So to say it's a retail ban is a little bit tough for me to swallow.
Thank you. Jonathan, there's a question for you in the chat actually that I want to ask before we move on from this topic. And the question is whether you or your stakeholders would support an Ohio bill that's modeled on Kentucky. So I think the question is basically, is Kentucky a model that your stakeholders think is a good one?
Yeah, and we have shared the Kentucky model with Ohio lawmakers, and in fact have put together legislative language that's very similar to Kentucky. But so far, there's been no takers. We're hopeful that once this debate continues, that it won't be as it has in the past, basically just up or down on a ban, and that people can come together on a more robust regulatory approach. So we're hoping that that happens, but we're ready to pitch in if it does.
Great, thank you for answering that. Are there any other thoughts on SB 86 that any of you want to share before we move on to talking a little bit about the federal level? Okay, so again, I'll ask this question to all three of you, and maybe I'll go in reverse order this time and go Michelle, Jonathan, David. But we have been talking about the state level. We touched on the federal level earlier in our conversation, and it would be great to hear, I guess, two different things. One, what changes, if any, do you anticipate or expect or think will actually happen at the federal level? And from your stakeholders' perspectives, what changes would you like to see happen at the federal level? Michelle, if you're good starting, I'll start with you.
Yeah, sure. I'm not sure what kind of changes in the realm of cannabis that we can actually expect at the federal level over the next 3.5, 4 years. But one that's on the table right now that I already mentioned, which is rescheduling marijuana from Schedule 1 to Schedule 3, which would, that could be really interesting. We'd like to see what the FDA would do with regards to this. We think it could alleviate some of the concerns and some of the hurdles and barriers that legal marijuana markets are experiencing within the states, and it would open up interstate commerce, which would maybe kind of lessen some of the concerns about intoxicating hemp, but also the interest in intoxicating hemp. We'd like to see federal guidance on inclusion of CBD and other cannabinoids in food, beverages, supplements. I know FDA says they don't have the appropriate frameworks to do this, and they need Congress to intervene. However that works out, we don't know. That's just something we would like to see happen, whether it's through FDA working with Congress or Congress, less likely with Congress, of course. And then, the hopeful one is we would like to see the federal government take a unified approach to these products. They're produced very similarly. They have very similar risk profiles, at the very, very least, good manufacturing practices would be something that the federal government, some kind of guidance document that the federal government could put out so that the states could follow, so that at least when we have products switching between states, being mailed or carried from one state to another by consumers, they know that they're at least being held to specific types of safe manufacturing procedures and labeling so that everyone understands what they're actually getting in the bottle, so to speak.
Thank you. Jonathan, so same question for you. Are there changes you actually expect to see at the federal level? And what changes would you or your stakeholders like to see?
So you're catching me right now in the Senate Dirksen cafeteria. I apologize if it's a little noisy, but I'm in the middle of lobbying on these various issues. And so there are two different approaches that have been taken when it comes to hemp. One is to ban it. There was Mary Miller, a congresswoman from Illinois, last year introduced legislation that would basically make criminal any hemp products that had any level of THC in them, and really put a scare through the industry. Fortunately, those efforts were not successful last year, but they could rise again. So we're being very vigilant. Our approach is, again, as I've been talking about, robust regulation. And the bill that I'm lobbying for has been introduced by Senator Ron Wyden from Oregon. And that bill would provide age gating testing, labeling, transparency, all of the various elements that we've been talking about today that would be wise for, and it would also give the FDA the authority that Michelle mentioned is missing right now in terms, or that FDA thinks they're missing. We think they've got the authority already, but they think they don't. But it would give them the clear authority to start regulating these products. So I can't give you a prediction as to whether that's going to pass. We're hopeful that by the end of Congress next year that we will see legislation like this, but there's a lot of work to do between now and then.
Great, thank you. So David, same two questions for you. Changes you expect to see and changes your stakeholders would like to see.
Yeah, I think I'll do what we'd like to see first. I don't think it was, obviously, I don't think it was ever the intent that we have this loophole in the law. So things that we would like to see would just be close the loophole. I don't think the federal government ever intended to allow these synthetic THC products to be available to consumers. You know, cannabis is one thing. Cannabis that's grown, naturally occurring THC is one thing. Synthetically producing it is a whole other thing because we don't know enough about it. You know, I think changes from a federal level, obviously, I believe that the banking side of things will ultimately get taken care of, and that would be a big help for our folks as well.
So there's a couple of related questions in the chat that I want to pose to you all, and you know, attendees, you know, please keep putting your questions in the chat. So one question is about what the questioner calls the 3-pillar approach. Perhaps this is what, David, you were referencing, and Jonathan, you as well, involving 3 key requirements: age restrictions, product testing, and truth in labeling. And the question is about whether the 3 of you see this approach as a viable regulatory framework, and if not, what would be a better approach? And I would add to that question, if this is a viable regulatory approach, would you want to see it at the federal level or at the state level, or both? Michelle, I'll start with you first because I see you nodding. So
Yeah, I'm not sure about both or either or. I mean, I think that is definitely an appropriate stance for the states to take, right? These, you know, David said we don't know enough about these molecules. The ones that naturally occur in cannabis, like Delta 8, Delta 10, et cetera, THCA, THCV, we know almost as much as we do at this point about Delta 9. Like, we know that the molecules are relatively similar. We know which receptors they attach to and what kind of effects they have. For example, the one study I've seen in humans of Delta 8 had a weak affinity for CB1 receptor, which is psychoactive, weaker than Delta 9 anyway. So it kind of created what they would call lighter high. That's why it's called diet weed. But we do think treating all of the cannabinoids from the cannabis plant, whether we're going to call it hemp or whether we're going to call it marijuana or cannabis, I think would be the smart approach here. I think a federal age limit is fine. If we, you know, generally what we want to do is treat cannabis products, regardless of hemp or marijuana, like they were alcohol. They are both intoxicating products with particular risks. We want to age gate them for adults, and we want them to be made safely, and we want people to know what they're getting. So yeah, I think that unified approach probably would work at the states and the federal level, so long as the federal didn't invade the states too much with their regulations.
Jonathan, do you want to chime in?
Yeah, my answer to your questions are yes, 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 and yes. We love the 3-pillar approach. There's a lot behind that. A lot more detail as well. There needs to be testing. There needs to be insurance that products are not marketed in a counterfeit way, not marketed to children. But that is the approach we support. We'd like to see that at the federal level. We'd love to see uniformity on a lot of this stuff at the federal level, and potentially some federal preemption, particularly when it comes to labeling, because of the concerns I mentioned earlier about 50 different labels. But in the meantime, since the Congress is dragging its heels and the FDA has dragged its heels, we'd like to see it at the state level.
Well, I was going to ask you about preemption as you were talking, and you answered the question before I asked it for our audience members who may not the lawyers, preemption would basically mean the federal requirements serve as a floor and a ceiling, and the states cannot require something different than what the federal government requires.
And let me be clear, we do think states can have different approaches on certain issues, such as, milligram limits. There might be, higher in Nevada than they are in Utah. So we recognize that states need to have rights on those issues, but we do believe in preemption on the limited scope of issues where there is no right or wrong or ideological position, like labeling, like packaging, because consistency is going to benefit everybody, both the manufacturers and the consumers.
And David, do you have views on the 3-pillar approach?
Well, I'll just say that it's a viable framework, and I know that because we've done it in Ohio in the cannabis industry. It exists, and we're already working through it, and it's proven to be successful. So yes, on the federal side of things, I think there are aspects of this that belong with state lawmakers, but uniformity is always good as well.
And David, I see a specific question for you in the chat about dispensaries versus other retail channels. And the question is, I think, sort of potentially related to this question of kind of what should be in a regulatory scheme, whether cannabis sales should be limited only to dispensaries or whether other retail channels are appropriate for selling cannabis products.
My answer is, I think in time, we may just not be there as a state yet where we're ready to have retail. However, seeing that we have these intoxicating hemp products in retail, I certainly think the playing field should be level. But to the extent that it's not, and going back to my framework that we already have established, we know this is a successful way of keeping people safe while also using cannabis. So that's my answer to that one.
And I think Michelle at least has already answered her views on that question. So, but I see a couple of questions in the chat about rescheduling of marijuana, and I will take a brief aside to plug that in April, the Drug Enforcement and Policy Center is having a webinar on the rescheduling process, as Yana just put in the chat, for marijuana that will include my colleague, Professor Bridget Dooling here at Ohio State, who's an administrative law expert, Professor Matt Lawrence, who's formerly a senior advisor at DEA, our alum, Kat Packer, who is a former state regulator, and myself with my sort of former HHS hat on, talking about it. So if you're interested in that topic specifically, please feel free to register and join. But the questions related to rescheduling of marijuana are whether rescheduling at the federal level, the proposal is currently to move to Schedule 3, not to completely deschedule, would impact, the question's about bills, but I'd say would impact any state laws, a move from 1 to 3. And then a sort of question that's unfair to ask, which is what the current wisdom is or what your prediction is about what will happen, given that the process for rescheduling started in the previous administration. So if you have any predictions about the likelihood that DEA will continue to move on this issue. So 1, any impact on state laws? 2, do you think DEA is actually going to complete the process? Does anyone want to start off?
I'm happy to. Yeah, in terms of impact on hemp, there is none. I'll defer Michelle and David on the impact on marijuana because it is substantial. Donald Trump endorsed moving to Schedule 3 during the campaign. And so I think that, there is still that same kind of energy behind it. The challenge is in DEA. The DEA folks that really resisted Biden, dragged their feet to get to the election. There's just a lot of hostility there. And so that is going to be the force. it all depends on one man. It's Donald Trump. That if he decides to make this an issue, then we've seen on so many other issues the Republican Party fall in line, and certainly his administration fall in line. So we're all looking to see whether this is something that he really cares about, or whether it was just a campaign thing that might get lost in the wind.
David and Michelle, do you want to chime in on whether there are impacts on state laws, or if you have predictions about what DEA will do?
Yeah, I'll go first. I have no prediction about whether or not this will actually move forward. If I was like had a gun in my head and I had to choose, I'd say nothing's going to happen. I don't think the current administration is going to make this a top issue in order to push the DEA to push the rescheduling forward. And when it comes to the impacts that could have on the marijuana market and the state laws, I think it would be very significant depending on what, for one, you get the banking issue. That's great. The biggest benefit would be that marijuana companies would be able to write off normal business expenses for their taxes, which would be an enormous tax saving. Right now, they're paying an effective rate that's absolutely crazy. But then it depends on how the federal government then decides to regulate these products, which I imagine if the FDA is getting involved, HHS is getting involved, then that would start to preempt or in some way conflict with what the states have already have established already when it comes to marijuana.
David,
Michelle,
add?
I don't have any additional thoughts because Michelle nailed it right there.
Great. Sorry, I'm just looking back through the questions to make sure I didn't go miss any. But so there are a couple of questions about the Farm Bill, the 2018 Farm Bill, and whether we will see a future Farm Bill that addresses some of these intoxicating hemp issues. Jonathan, I think your discussion of Senator Wyden's bill and the other federal bill that would be prohibition sort of gets at where the federal government is headed here. But do you all have any predictions about whether there will be, what the chances of success are for some of these initiatives at the federal level?
Yeah, I mean, as I mentioned before, we were able to defeat, when I was talking about the Mary Miller Amendment, it was the Mary Miller Amendment to the Farm Bill. And we were able, the Farm Bill died, but we were able to get House leadership, the House Agriculture Chair, to say that he didn't think it would be attached again to the Farm Bill, either now or before. And so I'm hopeful and I'm very optimistic that when we do finally pass a Farm Bill, whether it's 2025 or 2026, that it will not include any prohibitory language. And we'd love to see something like the Wyden bill attached to it. But again, a lot of water on the bridge and a lot of decisions that be made that have absolutely nothing to do with hemp or cannabis before we even see the Farm Bill moving.
Yeah, maybe it would help to clarify what the Mary Miller Amendment would have done, which is, I mentioned that under federal law, under the last Farm Bill 2018, they, defined industrial hemp as having under a 0.3% Delta 9 THC concentration. And the Miller Amendment would have changed that to be total THC concentration. So meaning THCA, all of the other THC isomers. So currently right now, the USDA estimates that around 20% of the harvested hemp in this country is just thrown away. It's destroyed because it's hot, because it gets above that 0.3% limit, even though it's not at all intoxicating. And this kind of gets at the problems of why hemp farmers were putting so much stock into the CBD market, because we don't really have a hemp fiber. We don't have a very well established hemp fiber market. The cannabinoid market is the one that is the most in demand, has the highest prices. So farmers are putting their money into that. Farmers are asking to raise that limit from 0.3% Delta 9 to 1%, saying that this would allow us to destroy less crop, to be more profitable, and still to keep intoxicating hemp out of the system, to make sure that it's tracked and maintained. So we are hoping that the Miller Amendment doesn't reemerge. We're hoping that the next Farm Bill will take, something like Jonathan talked about, the Wyden Amendment will take a more rational approach to this so that it helps both consumers and farmers and doesn't create the unintended effects that we're kind of dealing with now with Delta 8.
Thanks for explaining that. David, do you have thoughts to add on the?
Nothing to add on that front.
Okay. So I see a question in the chat that I'm actually very curious about. We haven't talked, we've talked about, or we've touched on the idea that children might be exposed to intoxicating hemp products, but I don't think we've talked very specifically about products that mimic children's food products. And so the question is about what the hemp industry's position is on intoxicating hemp products that mimic food products that are typically marketed to kids. I will assume that the position is it's not good if kids accidentally get these products. But what are some of the regulatory strategies? What is the industry's position on what kinds of food products are appropriate, and what are some regulatory strategies that your stakeholders think would be appropriate to address that potential issue of children being exposed accidentally to products?
Yeah, no, we feel we need much stronger protections against kids and against marketing to kids, and they need to be enforced, both in terms of what's on the package, how the products are sold to the general public, but also ensuring strict age gating. This is something that is easier to do in person and tougher to do online. And so we're really focused as an industry at promoting strong age gating online. Now, that is not, are you 21? Yes or no? That obviously doesn't work. It's kind of ridiculous. But there are new technologies that have come out in the last few years that are able to check databases, require the download of IDs, and make sure, and they've been used for tobacco and wine for quite some time. Apply those to hemp so that we can make sure that kids aren't getting online and buying those products.
Yeah, I would add to that, the gambling industry has done a great job of kind of laying down this model for you submit your name and then you get challenge questions. What car did you drive in 1998? What's your social security number, et cetera. And then they can match you to databases to know that you are who you, and for the parents out there who say, well, my kid has my credit card, well, my kid knows my social security, that's kind of on you at that point, like there's only so much the industry can do to make sure. But yeah, I just wanted to add that.
So I'll just add that the good news is that we already have all of these restrictions in place under through the Division of Cannabis Control. And if Senate Bill 86 goes through, all of these products would then be sold in retail dispensaries where we are age gating properly. We do have package limitations being constantly reviewed. Everything is pre-approved even before they start the process of packaging products. Again, it exists.
I do want to add one thing just to say that, as with what is intoxicating, what is appealing to children is one of those almost slippery slope issues where you're like, I would like to see states adopt, and this is where the federal government can kind of come in and help and say, these are our guidelines, because we don't want what happened in the e-cigarette market to happen for many reasons with any of these other products. But one of them being is this: bright colors are considered child appealing. We don't want to necessarily have the drab gray box, that you give to adults, but we obviously don't want known cartoon characters that appeal to children or advertisements that are aimed, where children will be more likely to see it than anybody else.
It is highly likely that litigation is going to ensue at some point on these particular questions of what is attractive to children, what is not. We're gonna have a court tell us where the line is drawn.
It's like obscenity, you kind of know it when you see it, it's unicorn poop or whatever, but if it's just Oreo flavored, is that necessarily? But yeah, I hope we get some clarity on that and some kind of principled stance from various stakeholders up to the federal government about what this means, and can adults still have fun while we don't market to children?
Well, we are right at time, and can adults still have fun while we don't market to children? I feel like is a nice question to leave us all with. I've seen a lot of comments in the Q&A thanking our panelists for their discussion and their expertise. I don't think we have the clap emoji in the webinar, but thank you, all three of you, for joining us. This was really informative and interesting, and we appreciate your time.
Thanks so much for having us.